A very warm welcome to all of you at LawSikho's webinar. Today evening, we are hosting a webinar on the topic, The Future with Public Interest Litigation. As the Martin Luther King Jr. said, injustice anywhere is threat to justice everywhere. So at today's webinar, we have a special guest with us, Mr. Jamshed Misri, an independent practitioner and founder of internationallegalalliance.com. He is skilled in various types of litigation, international law, media and entertainment law, and public interest causes. He is also an associate member of Canada Bar Association, advisory board member of South Asia Fashion Week, and a member in several renowned institutions. We welcome you, sir. Thank you for accepting our invite.
Thank you.
Sir, with this warm welcome, and I really want to first ask the very interesting question that, especially you being a practitioner, independent practitioner from last 2 decades, how has the landscape of public interest litigation evolved over the past 2 decades, and what strategic shifts have you observed in your experience?
Sure. So I think for the benefit of the audience, let's really go back in time. Let us see when did sort of public interest litigation, when did it really start and what happened. If you go back in history and you go back to the time, when we had the kings and the courts, in the sense you had the courts in the sense the court of the king. And at that point of time, and even with your panchayat system, you did have examples of persons going and saying that there was a problem which not only affected them but it affected the villages and so many other. So this concept was sort of already there, over the ages. uh, what really happened is in the modern times, if you get to see, it was at the end, sort of the beginning of the 19th century, that in fact the Supreme Court of the United States is a very interesting case where a person applied to the Supreme Court of the United States, as in by way of a letter, saying that he was an insolvent, he didn't have money to sort of appoint an attorney, and he wanted to represent himself, and that was debated uh, at that level, and finally the Supreme Court, by a majority decision, allowed him to represent himself for a particular matter which had consequences not only for him but for others. So that was a very interesting sort of start to this, concept in modern times. In India, it really caught steam in the 1970s, when several issues, where and the start was again an innocuous letter written by an NGO. In fact, it was called the famous Doon Valley case, where an NGO wrote to the Supreme Court of India, complaining of illegal accesses to mining and other issues that they had in that area. And the Supreme Court again took it up on its own and converted that letter into a public interest litigation, and that is how, and it was kind of formulated, and then of course it passed several directions to the center, and other agencies and things like that. So that was very interesting. My trieste with this subject actually started very, very soon after I actually graduated in law from the Government Law College in Bombay. And when, in fact, I joined my senior, and we were briefed in a very interesting matter. At that time, of course, interestingly for the respondents. So we were briefed for the BEST, that is the Bombay Electric Supply and Transport Undertaking. And what was the question before the Bombay High Court? The question was, just as in Delhi, you had the problem of blue line buses and things like that, because they found that the They were spewing, thick, dark, sort of, smog literally out of their exhaust pipes. A similar petition was filed by an NGO called Smoke Affected Residents Forum from the very polluted that time Chembur area in Mumbai. And of course, that's taken up, and we were appearing on behalf of the BST. So, what happened at that time was we had a former Chief Justice who, looked at the council appearing and saying, no, BST, you know, is not complying, and we'll have to shut your transport undertaking down, and so many other things. So we actually then, it's very funny. I had not touched physics, chemistry at all since leaving school, and suddenly we were thrown into this problem, which involved compressed, because what was the alternative at that time? It was CNG. Now, what was CNG? What did it need? How did it affect combustion, and etc. etc. We actually had to study that. So science as a subject, it came back in a very interesting way, and we went through, and a fascinating solution was found. We found that the BST at that time, because of they had a very small number of fleet of buses, 3,500 for the entire city, and we found that only that because of the coverage, the distance that it covered every single day, and in fact in a year it covered half the distance from here to the moon. They did such a lot of running, and they used to change their engines every 6 months as a result of it, because of wear and tear. So the question of pollution was much less. But anyway, I won't tell you the entire story, but ultimately we were able to convince the court to give the BST enough time to phase out its diesel engines, and fit it the engines initially with CNG. Of course, CNG, please remember, was very expensive at that time, and there were only certain Italian companies making, the all the equipment and things like that. But ultimately, the entire transport bus, taxi, auto rickshaw, everything was changed to uh, a, a, a fuel or a gas which was otherwise being burnt in the air as excess. So that was a very interesting, you know, introduction of mine to public interest litigation. After that,
Yeah.
of course, things just happen to you sometimes as a lawyer. And uh, the next case that came to me was another matter of very, very great importance. A orthopedic surgeon, one Dr. Sarosh Mehta, came and met me saying that a lot of persons were falling off from the Bombay suburban railway tracks, and that resulted in about maybe 10 deaths a day, and he was very concerned. And that time, first, the Bombay High Court had dismissed his petition on the ground, saying that the railways is not responsible for the overpopulation of the city, and on some silly ground like that, his petition was dismissed. Anyway, he came, we filed a review, we got it restored, and I think ultimately it took over 18 years. I mean, we got the entire system changed. Now there are clinics which are on railway stations. The golden hour principle, which involves that the injured person or passenger is taken immediately to the nearest hospital, whether private or government, and he is treated immediately. This is in keeping with the Supreme Court guidelines as well. Ambulances were made available. Earlier, ambulances were being used to transport vegetables. I mean, you'll be shocked. When we had taken inspection, we found that ambulances were not patients, but things like that. And we even traveled with the engine driver to actually see what happens. And it was terrible because people used to cross the railway tracks haphazardly. And he said, listen, if I stop, all the bogies at the back, might topple and we might have a bigger problem. So it was very interesting over a period of time. And we, of course, we finally got the railways to accept that there was a problem, and slowly to get it done. And hopefully now, uh, the number of deaths have come down drastically. I mean, keeping in view, population of our city. So that was sort of very interesting. Of course, subsequently we've had our share of blasts at railway station. Then how do you take care in emergencies, and so many other issues came about. So that was interesting. In 2000 and I'm just going back and forth on dates. I was also briefed very interestingly in another matter, again directly, as what is called an amicus curiae, which means that the court appoints you directly to assist the court. That is, I mean, you are not the petitioner's lawyer, but you are there to assist the court in a particular, you know, sort of manner, uh, because they feel the need to that you can assist them in certain areas and give your opinion to the court. So I was appointed as amicus in a very important matter where the question was that poor and indigent patients were not being admitted to private charitable hospitals. Now, most of the hospitals in our city and state are run as charitable hospitals, and therefore, we don't have social security as a rule, as people abroad have. So we what the court found was that people, in fact, it was an advocate whose father needed some, assistance, and he wanted to, as per the Bombay Public Trust Act earlier, 10% of beds had to be kept for poor and indigent patients. Now, that was obviously not being followed. So we, through with the charity commissioner, who actually sent somebody from his office to, wearing slightly torn clothes, to a hospital to see whether he would get admission. And well, the, that gentleman was actually literally, thrown out by the guard, saying that get out. This is not the place for you. So we filed his affidavit, and he got the entire process stayed. Then all the heads of these hospitals came and met and said, no, we are doing a lot of work and we are taking care. We said, no, sorry, on the ground it shows otherwise, but let's sit down together, let's frame a scheme. So a scheme was framed under a particular section, Section 41AA of the Bombay Public Trust Act, and which finally it was agreed that 2% of the monthly income of the hospital is set aside for such poor and indigent patients. In cases of emergency, you have to admit irrespective, and you have to treat them. So, and this was then, of course, accepted by the state, and this has now become a part of the act. So it's very interesting where you have, a litigation followed by some sort of guidelines or a document that is sort of made in consensus with the parties, and then that goes back and forms a part of legislation. So this was a very very fine example of that, and that is in place even today. Following that, of course, we had the issue of when two persons with disabilities, actually students from the ILS Law College in Pune, they had filed a petition saying that the 1995 Act of Persons with Disabilities was not being followed, especially with regard to buses and transportation. And those students, they came and met the institution called ADAPT, between the able and disabled people all together, which was called formerly the Spastic Society of India. And their problem was they said, we are not able to demonstrate to the court the disabled person's perspective in this litigation. So we said, fine. And they asked me if I appear for that institution. I said, sure. And we went to court. And what happened was, I mean, as you know, the Bombay High Court building is a big structure. So at that time, of course, security was not a problem. So the taxi with these two, persons came. They were both on a wheelchair. They got off, and then they were literally physically lifted from the ground floor. They were then, of course, fortunately, there was a lift taken to the first floor. Their affidavits were affirmed, then taken to the second floor, and things like that. So this kind of, disconcerted me. I said, this is not right. I mean, how it's taking them almost an hour. Luckily, we had the matter in the afternoon. And after we made the application for intervention, which was allowed, I did take the liberty and tell the then Chief Justice and of course Justice Chandrachud, who's Chief Justice of India now. He was the junior judge, saying that I'm really sorry, but these persons with disabilities, the applicants, it took them over an hour to even reach the court. So, I mean, can you imagine what would happen to others? And that we have no facilities whatsoever. So they were, of course, initially stunned and they said, okay, okay, and we'll look into it. Well, interestingly, two cases thereafter, they called me back on the podium and they said, Mr. Mistry, we've heard what you had to say, and we've immediately directed the Protho Notary, who's the administrative head of the High Court, to allow the use of the judge's entrance for such person till such time as adequate facilities are made. So, fine. And what was the facilities that came up, which was, I mean, absolutely hilarious. They cement concreted some steps, put a rickety railing, and put a heading called ramp. I went back to court. I said, I'm really sorry. An able-bodied person himself will get a high percentage of disability if he uses this. So please, let's get. So the Chief Justice called me in his chamber and he said, Mr. Mistry, what is to be done? I said, please demolish this. Let us there are architects, will design a proper ramp with the Public Works Department. Let's put it together. It took several months. Finally, by then, that Chief Justice was elevated to the Supreme Court, and we got Justice Dalveer Bhandari as the Chief Justice. And in some other context, some other matter, I raised this issue. I said, what type of a High Court are we? We don't have, facilities for disabled persons. So he immediately called for the file, and he said, in court, he immediately said, let this, be sanctioned immediately and let it be done. And of course, thereafter, it was done, and that's how at least the Bombay High Court had the ramp railing and toilet blocks, which was the basic infrastructure required for the persons with disability. Now, interestingly, this same issue came up before the Goa bench of the Bombay High Court, where we had another former Chief Justice, Justice Lora, on the bench. And I remember telling him that, this is an act of 1995 and we are in 2005 and nothing has happened. I mean, he was so upset. He said, issue a non-bailable warrant against Secretary Social Welfare Department and bring him to court. He said, this is absolutely not done. The poor gentleman came, he tried to explain, he said, nothing doing. You have to ensure that, as you know, Goa is a bench of the Bombay High Court. So we finally suggested to the court that let the NGOs and the government sit together and frame a scheme, which was also what the government was supposed to do. Anyway, but they sat down, and that particular scheme, after, of course, it got approved by the High Court. I think it was a year later that I get a call from the same secretary who was being hauled up at that time, saying that he was invited to Delhi to actually receive the President's Medal for being the most progressive state as far as disability is concerned. So it's very, that was very interesting that you were able, the court was able to convert a person's thought process, and he was able to get all these things done. So that was very, very interesting. Of course, in disability legislation, I had even appeared against my own school for you know where two students actually at that time dyslexia was not considered, an important. It wasn't considered a disability, but uh, and actually I had appeared for the counselors association in that particular matter, and we found that the students were not getting extra time and things like that. Again, we were able to convince the court, and as a result of that, lakhs of students even today. Of course, in the 2016 Act, it has been now agreed and approved. Number of disabilities has gone up from 7 to over 30. So that is again something which was very, very good and very progressive. The several other types of you know uh, public interest litigation. I mean, I remember one, for example, where bonded labor, where it was found that some uh, very unfortunate, just a few kilometers away from Mumbai city, uh, bonded labor were actually killed because they were not able to pay back 50 rupees a month. And that was a letter that we sort of not only got the family to write, and that was reported in a newspaper article, in fact, and we presented that to the then acting Chief Justice of the Bombay High Court, and you know uh, yeah, were able to prevail upon him to take it up on a what is called a suo motu basis. So that was again a very interesting case where a newspaper article written was taken cognizance of by the court and converted into a public interest litigation. So that was amazing. Uh, in I think 2008, of course, we had the famous abortion case of Nikita Mehta. Now, why do we? Although it was not styled as a public interest litigation, why was it? It was of immense value because at that time, under the Medical Termination of Pregnancy Act, you could beyond 16 weeks, it was considered an offense, and this was the first time that it was kind of taken to court and shown that in a given case, in case there is a problem, and I believe at that point of time there was a problem with there was a hole in the heart of the fetus, and the doctor was absolutely convinced that something needed to be done. So that actually opened up the law, and of course, many years later, now the law has changed, and the courts are looking at abortion in a very, very different sort of perspective than they did in 2008. Uh, I mean, we've had to for the I mean from important festivals like the Kalagoda festival to beach safety. I mean, for example, drowning deaths. That was another major sort of problem and issue on the beaches. And while people went to swim on a holiday, and rip currents would sort of pull them in, and as a result they would lose their lives. So to actually promulgate, to get the state to ensure that there was sufficient number of lifeguards, etc. That was again one had to use the. There was an NGO who actually filed, and finally we were able to get these lifeguards on the beaches, and I think that was another very fine example. Uh, of course, currently I am the amicus in another very interesting matter with regard to related deaths, and that is still pending. Of course, there's a contempt petition pending, and we should be having hopefully a final hearing on that very, very shortly. So I'll just step back, and again, I mean, these are uh, examples, but I think importantly, for the benefit of the audience, what is the difference between a regular, uh, you know, case or writ petition and a public interest litigation? So a regular writ petition is where you are personally, affected by a particular case, and you want relief with regard to yourself, or your body, or that institution. In a public interest litigation is when you are you filed something which is not necessarily for your personal benefit, and in fact that is important. Ideally, it should not be. And thereafter you are taking it up for a certain section of the society or the community which has difficulty in coming to the court and taking these issues up. So that's the difference. Earlier they used to be styled, all petitions were just writ petitions, but then starting with, I think, in the 90s, I mean, at least in the Bombay High Court, they used to be styled, and now they are styled as PIL number so and so. So there's a complete distinction. What is important is, you have usually one or maybe sometimes more benches of the High Court, under especially in 226 and 227, Article 226 and 227 of the Constitution. Of course, in the Supreme Court, it is Article 32, where you can approach the court directly. But it is important to know that these petitions are styled in a particular way. There are rules now that each High Court has framed on how public interest litigation can be filed. You have to follow them very, very strictly. uh, there are issues which are debatable, whether can a newspaper report be converted into a PIL? Of course, it can. These are all discretionary powers that the court has. Sometimes when you show a newspaper report, they say, "Oh no, please get us more evidence." That is not enough. And so it's very interesting, and it's kind of evolving. So I think I'll pause here for a minute.
So I would like to ask that, like, can a PIL be filed for five people, or it's like this minimum number, or it should be large number of people?
Well, it of course it has to be for it may be initially, like for example, the one uh, relating to learning disabilities. There were two students who were affected actually, and they were thrown out of their school. But what it did was, because they were thrown out, and the High Court in its jurisdiction was able to get certain guidelines framed, that those guidelines eventually helped and continue to help lakhs of students who are giving these exams and tests, etc., in the schools today. So the effect can be so. So to answer your question, yes, two or three people may file. It might be affecting them, but in the larger sense, it would affect you know so many more over a period of time.
Thank you, sir. Thank you for your answer. I mean, it's really, clear. My mind is getting clear about what PIL is, being a lawyer, how you can use this as a weapon, how you can help millions. So, now I want to ask something from the lawyer's perspective, that what challenges do young lawyers often face when they are dealing with PILs, and how they can, fight with these challenges, and how to overcome, and how it will help them.
Sure. So I think, see, I mean, I think I am probably interestingly suited to answer such a question because I probably did, as I explained earlier, I did my first PIL just a year or two after I joined the bar. I mean, and there are some, of course, law students who have done it even while they are in law college. So that's interesting. But I think there are what is important in especially as a young lawyer. Why only young lawyer? Even however experienced you are. So law is continuous learning. It just doesn't stop. It's so vast. The important aspect is that whatever case or matter you have, first and foremost, you know. Uh, you should have have done as far as possible with the help of your client uh, a very detailed factual study of the problem, and that you should put before the court so that the court, on looking at it initially, because you must understand that there are several public interest litigations which come up. Say, like for example, Bombay High Court has a particular day. It's a Wednesday. The PILs are taken up. On others, it may be any day. But you must remember that you should look at it from a judge's perspective. When the matter comes up before them, whatever is there should be factually very detailed and very accurate. Quite often, because of the lack of details, PILs get dismissed. So that is number one. The second thing is that you must also check and put in, if possible, either sort of case law, if you can't find any in your state, then from any other states, and of course the Supreme Court, etc. And if you still cannot find, then you should by all means look at maybe precedents in other countries and other countries have dealt with. And then, of course, apart from the relief that you are seeking, you must also give have enough sort of suggestions to improve the system. I think that is the court also looks at a petitioner not only to solve his problem, but to for his suggestion to solve the larger problem that is brought to the court. That is again sometimes where I feel that where the court asks a younger lawyer, and maybe he or she is never exposed to this, so there is a little bit of hesitation on that front. And of course, you should be very very clear in your mind. Doesn't matter, even if the judge shouts at you, howls at you, does anything, you should stand up. And I have seen that sometimes they may be totally against you for the first 1 hour, and then at the end of the next 1 hour they're completely in your favor. So it's like that. It's how you put it across. Keep it simple, keep it straight. Don't try and sort of tell the judge anything which is sort of incorrect or inaccurate. Just explain to them the fact. This is the fact. These are the case law, and this is what it is, and this is what we need. And then, of course, after the respondents they file their replies, you should be able to point out what the inaccuracies are and what additionally needs to be done, etc.
Yeah, thank you, sir. So, is there any court fees for filing a PIL, or anyone can file it?
I think
Mm.
it's very minimal. It's very minimal. 100 to 100 rupees is the. It's not the regular. It's not doesn't follow the stamp act and things like that. So that is also important. So you jumping the queue. you're not in line with regular litigation, and because of that uh, you're given preference because the court thinks that this is an important issue of public importance.
Yeah. So how a lawyer can keep a balance with the fighting for the public cause and then maintaining a professional this advocacy
So
also.
I think
How?
you should go back. I'm sure every lawyer has had ethics as a subject, and one of this very uh, interesting question, at least used to be asked, I'm sure it must be asked in law papers, was law is a noble profession. So this is where your nobility comes out, where you you should try and do something for you know the disadvantaged people who cannot afford, and a certain amount of pro bono practice is always good. I mean, you could be very busy doing commercial work, fair enough, but in your own way, in whatever way, you know, if you can do, I think there's a huge need and huge requirement for for this. And I mean, whether you're senior or junior, it doesn't really matter. But I think it helps, and importantly, it sort of it strengthens, a your legal knowledge, because again you'll be dealing with subjects which you are not otherwise either familiar with or uh, are in regular practice with. So that's the interesting part. And if you and my suggestion is, as a young lawyer, if you get an opportunity to do a public interest litigation, please take it up.
Yeah. Even if you can, I would like to add something here that even if a lawyer can do something, for example, they can just write an email about a particular,
Yeah.
problem in the society. Even even just they can do this much. This is also going to give them a big meaning
So,
to
and
provide
if
it.
there's an important method, I mean, apart from, of course, filing a regular, a public interest litigation in the, and as you know, of course, it can be only in the High Court or in the Supreme Court. You can also write by an email, address it to the Chief Justice of the concerned
Yeah.
High Court of the state, or to the Chief Justice in the Supreme Court. And if they feel that there is merit, then they take it up and convert that into a public interest litigation. I mean, for example, a gentleman, he he wrote to me actually, saying that there is a problem about, he was on a wheelchair and had problems about these bollards being there on roadsides, on the footpaths. And when I presented and gave it, handed it over to the Chief Justice, he has converted it into a suo moto public interest litigation. So there are so many such cases that do come from time to time, and that is and we are actually very fortunate that we have access to courts like this. I think that's something that we should remember. In other countries, it's not so easy. I mean, Supreme Court of the United States doesn't sit only for a few months in the year. Our Supreme Court sits every single day. I mean, of course, except for holidays, that's a different story. And what I would also like to bring in here is very interesting. Is we because of the the work that I was able to do in Canada, I also this whole issue of stream and how it came about. That was again a very very interesting case where you know uh, Miss- Mrs. Indira Jay Singh, senior advocate, she had filed a public interest litigation, and then they were all clubbed together. And I remember actually giving her a call and saying that this is, you've really done a wonderful thing. And I've seen how, uh, you know, uh, live streaming of cases makes a lot of difference in transparency. And we added another aspect where we argued with her in the Supreme Court to get transcripts done, legal transcripts. And why was legal transcripts so important? Because I noticed in courts outside of India, whatever you said in court, okay, in India, never got recorded. So if what I've argued in court half an hour ago, either you won't remember verbatim what has happened, and that was actually a problem. And we did a lot of research, and you'll be surprised. I found one of the that transcripts were part of our Indian legal system in the common law system, and I found a judgment of Bal Gangadhar Tilak of 1908, which was transcribed. Now, how did that happen? I mean, there was nothing like the word electronic was never discovered. So they used to use stenographers. They did the same for the legislature. So even our parliament and our assembly, everything is recorded. How? So they used to use stenographers and they used to use them and change them every half an hour for accuracy. And that is how it started, of course. And then, you know uh, now, of course, thanks to AI and everything else, you're going to see a huge change, that every court, from the lowest court to the Supreme Court, of course, has now started constitutional matters. Transcripts you get immediately, but I think uh, in the next 2 3 years you will find this happening across all the courts, and that
So,
is such an important aspect, because you today, if I go back and look at what I have argued say in a Canadian court in a particular date in a particular year, I will get all that. That helps not only us as lawyers, it helps the judges, it helps you know reporters, it helps everybody. So at least that is, I think, a huge sort of contribution that we've made to the system.
yes, so definitely it is a big contribution. So, as we just speak about AI, what future, how it is going to change? Like, if you could, guide us a little more, how the AI is going to change in future. Do you think?
No, I mean, it's very interesting. How I think, as long as there is courts, as long as there is democracy, as long as we have a vibrant judicial system, I think uh, public interest litigation will always be there. We'll always have, you know, sort of the use of it as a corrective measure. I think we may, I mean, it's a very interesting concept. Uh, just as you have, you have a judicial accountability and a judicial academy, you have the bar council for the lawyers. In future, I mean, just a thought, we might even have a litigants council. It's important because today, for the litigant, apart from the fact that he is the entire system is supposed to be for his benefit, okay? But quite often, I mean, for a variety of reasons which I don't get into, he is the one that actually suffers the most. So we may see a concept like that uh, coming in future. I mean, also, things like legal resource centers, which are uh, again very interesting concept, where then that's not legal aid. Legal aid, of course, is separate. It is available. It is state run, but you could have resource centers uh, which give very accurate legal information to litigants, so that they can then use that and then approach their uh, lawyers, and who obviously don't have a lot of time. And for today, you have a litigant who comes and says, I don't even know whether it's a civil or a criminal case, whether it's consumer or something else, etc. So a lot of time gets, I wouldn't say wasted, but spent. Initially, maybe a junior lawyer trying to understand what exactly the case is, and then it goes to here. The litigant can, be. much more informed, well, better educated, and then go to a lawyer and and take it up. So these are interesting concepts which are there. I mean, they've been uh, some countries have tried it as well, but in future I see that things like this might actually come to India.
Yes, yes. I think it will be very beneficial if it comes to India.
So I think I can also give maybe one or two other examples for the benefit of students, and that also with regard to the use of technology. I think as we all sort of realized, and as pandemic has taught us, uh, what what is important is now uh, virtual hearings have sort of course during the pandemic it was you had no option, you had to go virtual, and all courts had to go the virtual route. But today I think the hybrid system is here to stay. It is being encouraged by all courts, and and what is sort of you know the difference, and how should you deal, and because we all know that appearing in court, in the presence of a judge, and appearing online, etc., not only within India but even outside, I think the student should now, as a part of his curriculum, be taught uh, uh, you know how to, because sort of there are differences, there are sort of slight nuances on how you uh, what you say, what you sort of the approach should be. It's not drastically different, but it's definitely you know uh, different in that sense. And I think that is something that uh, one will see. Uh, and I definitely like law colleges to take that into account, especially in their drafting, pleading, uh, and conveyancing subject and especially within their moot courts, to get the students more acclimatized and are more acquainted with you know appearing virtually and in the so virtual and hybrid moot courts should now become uh, you know part of the legal system.
Yeah, right. So, and now actually my internet connection is a little bit interrupting. I'm sorry for the internet delay. Sir, now I would like to ask that are there any specific areas or issue you foresee becoming prominent in the PIL landscape in the near future?
Are there any?
Are there any issues that you see that are becoming prominent in PIL landscape future in future,
I think
especially with the AI technology, it's
yeah.
increasing.
Correct. No, no. I think all you need to do is, put on your, live TV from Supreme Court and all the other high courts, and look at the various chief justices, and you will see that, you know, uh, I think the type of cases are you know pretty sort of similar in nature, in the sense that so of course the Supreme Court decides the constitutional validity or otherwise. So that is what I'll give you. Yes, a very good example, and I'm glad you mentioned it. For example, organ transplant. Okay, in fact, our International Legal Alliance, our members, two of them had taken this up, and we were also involved in it. So what had happened was, the question is that you require domicile in a particular state in order to receive a organ transplant. That was the law. And what happened was that, in fact, this particular person was, in fact, a Canadian national, but having an OCI, and person just could not, receive an organ transplant in their particular state. So we filed, first, of course, the important aspect, like in all other PILs, is that you must write, first to the government and ask them to respond. They did not. And so this was heard by the bench of the Chief Justice in the Supreme Court, and he directed the Ministry of Health to immediately take cognizance of this. And as a result of that, they did, in fact, and overnight the law has changed. In fact, so much so that the Prime Minister, in one of his addresses to the nation, brought this out and said that we have changed the law. And all that happened was just because a public interest litigation was filed in one hearing.
Wow.
The law is changed. So yes, so these are interesting sort of developments which take place all the time. I mean, whether it's the environment, whether it's health related issues, whether you know uh, it can be anything. So the the canvas is very wide, and as we sort of go on, I think it's to do with human beings. As whatever happens, with us, and as we evolve, our laws evolve, and therefore litigation evolves.
So as we see our surroundings, we find so many problems. But don't you think there are very less PI getting filed? There should be more PI.
I I don't no. So there may be you know so there if you for example, uh, again, I'm just comparing. See, uh, in places outside, typically what happens is you write to the government or any other authority or agency. They they usually take up the issue. Here what happens is that some of them have this attitude that unless you take me to court, I don't need to do anything. I think that is, and they've been sort of, you know, getting, more and more immune. Yes, perhaps rightly so also. The courts are also very slow in using the contempt action against. Uh, so, for example, if an order is passed and then you file saying that they've not acted uh, on the court's order, then of course the question is that in contempt, is it willful disobedience? What is the threshold, and who is held responsible, and all these issues come into play. So I think that as a mechanism, because typically if the court passes an order and the petition is disposed of, you know, their jurisdiction ends. Then you have to again bring it back to the court and say that, well, you passed this order, however, it is remain non-compliant. Ideally, when you bring it back to the court puts pressure and it gets done. That's typically how it happens. So this perhaps is, and of course in our courts today, because of the time lag, this may be one of the reasons why people prefer not to. And of course, over a period of time there have been sort of gross delays because of backlogs and things like that. but otherwise no. And today, of course, the you have social media, which is an interesting public interest
Mm.
mechanism that is used quite often. Somebody puts it up on Twitter, and the authority acts immediately. So that's fine.
Exactly. Yeah. So anything you would like to you like to give advice to young lawyers or professionals who are aspiring to be to be a litigating lawyers, and especially in the public fight for public cause. Do you have any advice for them?
Sure. I mean, I think you know. As I said, these things came to us, by chance, and we took it off. I mean, if you had asked me after finishing law college, would you be actually arguing a public interest litigation? I would have looked at you and said, "What is wrong with you?" But no. I mean, we spent a lot of time and continued, to do that. And I think it's very very it's a very interesting subject. As I said, it is the most interesting aspect is each sub. Matter is different. It's not the same. So you'll find variation. So that's also very good. And the other important thing is in public interest litigation, remember that you are actually stretching the law and getting new law made through the courts. I mean, to at least to some extent, of course. Or they can then recommend to the legislature that a new law needs to be framed. So these aspects are very very exciting, and you don't get those opportunities in other litigation where it's mainly law that is laid down is then implemented only. This is a new, and it can a lot of suggestions, lot of common sense quite often is utilized to sort of solve problems of people across. So yes, it's and the other thing, of course, is you can use free to use, protocols, conventions that are internationally binding on our country and things like that as well. So yes, for a young lawyer, uh, it's a it may not be monetarily satisfying, but apart from that, you know, I mean, legally and educationally and and personally it can be very very satisfying.
So one last question. With just not I'm not going to give you more time. I just want to ask, how can international legal framework and collaboration contribute to the success of PIM, and also the addressing global challenges?
So I think you know uh, you know it's very interesting. Lawyers are bound by geography, so that's one, especially as far as India is concerned and things like that. But quite often, the challenges that you face in India, maybe same problem happens in another country. I'll give you a great example. I mean, the fact that we uh, I mean, live streaming of our cases. In fact, uh, we had US trained barrister in Pakistan who actually came to us and said that we would like, all the information. And uh, well, to his credit, he was able to get live streaming of their Supreme Court and other courts started over there. Why? Because they were able to see what we were able to do, in Gujarat and other places, and in our Supreme Court as well. So I think this is just one example, but I think in so many issues, whether it's the environment, it's issues of, for example, the living will. That's now getting into the courts and social media. So many issues. Uh, Globally, getting the views of lawyers and getting them to collaborate in a meaningful way. I think think that's absolutely important, and that's how you can work together.
With this, we can end this session. Okay. So thank you so much for this insightful session. I really enjoyed the conversation. It was very insightful. I understand my powers as a lawyer and how we should contribute towards the society.
Thank you very much.
Thank you for joining me.